Welcome to our Spotlight video series where we talk about cutting edge legal issues in the news. I'm Tom Spiggle, founder of the Spiggle Law Firm. We help people who have been fired or afraid that they might be. I am thrilled today to be joined by Ross Fedora, who's going to be talking to us, I believe, about ADA accommodations and telework.
Yes, I've been looking in the news lately. I've been seeing a lot of claims arising under the ADA that stem from failure to accommodate work from home requests. It's a very fast-growing area as more businesses kind of prioritize hybrid workplaces, and after COVID have shown their capacity to allow workers to work from home.
Yeah, absolutely. And, I think the landscape has changed a lot because now people are aware of the possibilities of remote work, certainly much more so since the pandemic, right? Prior to the pandemic, remote work was a little bit, it wasn't an anomaly, but it was a little more rare. But right during the pandemic, even courts had to learn how to use Zoom and work remotely. So I think now you've got judges and lawyers who are much more educated about the possibilities of remote work. But anyway, let's talk about the cases that you found.
Back in September, there was two ADA cases I saw in the news. One was against Booz Allen Hamilton and focused on workers' requests to work from home due to their migraines. And interestingly enough, both of these cases stem from before COVID even started and everyone started working from home, which I find interesting because conversations have been going on for so long. And then the other case stemmed from a Bank of America employee who wanted to work from home to manage their anxiety. Sadly, both these cases settled, so we didn't really get to see the full analysis that courts will use to kind of determine what is an undue burden in the context of work from home, especially under COVID. Especially with these giant companies too, it's hard to imagine how it would be burdensome on them, but there's a lot of different factors to consider, like different industries. Something like banking and consulting, you might imagine being in person and has a lot of benefits versus other positions like IT or something that's much more technology based. So it'll be interesting to see how these cases, if they do get before judges, how they kind of handle the different industries and translate that analysis.
Yeah, absolutely. And as you mentioned, both of these cases settled, so we didn't get a resolution. Both Booz Allen and Bank of America denied that they violated the law. But I think what was interesting to me in the case against Booz Allen is, she had been working from home for some time under an arrangement with the company. It sounds like she got a new supervisor, if I'm not mistaken. And he took a dim view of her working from home. The company did ultimately, I think, grant her request, but then according to her, he was abusive to her, at least verbally in front of people. And I guess she was later terminated, or I can't remember what happened with the case and how she ended up filing it.
I don't recall off the top of my head, but.
Yeah. In any event, I mean, the other interesting thing about that case is I believe the judge dismissed, this is just an area, just a pointer about, employment law practice generally. And that when the court dismissed a number of her claims I believe it was at the motion to dismiss, or dismissed summary judgment. Anyway, dismissed a number of her claims, but left the ADA accommodation, improper denial of her accommodation request. And then both sides had briefed it for summary judgment, and summary judgment had not been decided. It's settled while those summary judgment motions were pending, which is not uncommon. Once a case has been briefed for summary judgment, the judge has a lot of material before him. All the parties have a lot of material before them. And with those cases, with the decision pending, it's not uncommon for both sides to get motivated to settle. Because I think in that case, there was she had a retaliation claim, presumably because of the treatment from her supervisor, which was dismissed, which the article didn't go into why that was. And then in the Bank of America case, it was also, I think that one it sounded like it was settled before there was much briefing in the case. But one of her claims was that the bank retaliated against her for filing an EEOC charge, which is another another common thing that we see. Again, we don't know how this would have come out on the merits, but even if she had lost her ADA claim, like a retaliation claim, like if a company does retaliate against you after you file an EEOC charge, you don't get a much brighter line for retaliation than that. And those can be really damaging cases for an employer, or at least very difficult to disprove because you've got a timeline, right? I mean, it's just, hey, I reported this, which I genuinely believe to be true, and then the company did this, whatever, fired me or demoted me or refused to promote me or whatever protected activity there is, at some point after I filed that charge. And sometimes it's just hard to beat the timeline. So just a practice pointer for all of those. But I think it's a good reminder that the ADA is alive and well, and telework both creates a lot of possibilities for accommodation, but also creates some possibilities for things to go wrong with ADA cases for workers, and to be aware of that.
Yeah, I think one of the most interesting parts is the just variety of different ways and reasons someone would ask to work from home. I mean, these two cases, one was anxiety, one was migraines. I've seen other cases where it's been someone who's blind or handicapped, and they'll ask to remain at home after COVID and stuff like that. So it's kind of hard for these companies to argue with these plaintiffs, but at the same time, these employers might have very good reasons for explaining why they need people in the office.
Oh, yeah. Yeah, I think that's an important point. Just because your employer has a return to office policy doesn't mean they're violating. First of all, you have to be covered by the ADA. You have to have some sort of condition that would qualify for protection under the Act. If you don't, well, then if your company wants to bring everybody back in the office, then it's entitled to do that. But if you, and I think you raised a good point, the ADA has a pretty broad reach. There are a lot of conditions I think people who don't practice in this area would not think of as covered as disabilities. Migraines being one, really serious anxiety, postpartum depression, a lot of these sort of mental health related conditions, if they are severe enough and ongoing, can be covered by the ADA. And companies, again, the law may not require the company to allow you to telework, but they have to engage in what they call the interactive process, right? Where we negotiate some way that allows you to keep your job and perform the duties of that job with your disability. And I think it's interesting. Yeah, it'll be interesting to see what cases coming through the pipeline, that happened during and after the pandemic, how courts treat those, because I think it's more difficult with people with disabilities that could be served by working from home for a company to say, well, that's an undue burden for us, so we're not going to accommodate that. So, but we will see. I think we're going to see more of those cases coming out. And like you say, it'll be nice to get some, these were decided without opinions from the court to get opinions. But, they were interesting enough to get reported in our legal press, so people are watching them. Yeah, anything else on your end? Any other thing you found interesting about these cases?
Nothing else off the top of my head.
Yeah, good. Well, I appreciate you bringing them to our attention. Very important. And I will let you get back to the next thing on your desk.